We should be live, everyone. Thank you so much for joining us. We are here today with Nathan, and we'll get to the other Nathan in a minute here. Nathan, how you doing, man?
Very good, very good. How are you?
Cool. How's it up? How's the week been treating you? I guess things are a little breaking. The spring's kind of warming up a little bit.
We're getting there. It's raining today. We're all shocked. We're looking at pictures from the last couple of years, and it's so much warmer than it normally is. It's nuts.
Yeah, I think for me, the awesomeness of it is I enjoy the spring, but I don't like it super hot.
We're getting there. It's raining today.
And we apologize, gonna replay here. For me, I don't like the super hot, but I also don't enjoy when it's like super cold, right? So I enjoy that mixed kind of weather. Who knows what it's like, mid 60s kind of thing. So for me, it's enjoyable. Canada, what's your high in Canada? What kind of summer you guys get?
In the summer, it gets pretty warm. We'll get up to. We'll have a few weeks at least of like 100-degree weather. Like it'll get hot. Normally it'll be mid 80s, low 90s kind of thing. So it gets warm.
That's crazy. We are here today. So I think for me, for summertime for us, we get in those hundreds, but we also get the nice cool nights, which I like. I couldn't imagine living south. Wow. Back to business. What you been doing this week? Anything that's gone on for you this week at all?
Yeah, I got a couple notes under contract that I'm purchasing. Put in bids for another 8 or 9.
Okay.
See how it goes.
So we put in a few bids. This week was kind of a low for us. Were most of your bids CFDs, or what were they mostly?
It was actually, I think it was the 2 that I just got under contract are both mortgages, and then I've got another 7 mortgages and 2 contracts for deed that I've bid on.
Wow, that's awesome.
Most
it's a busy week. A lot of due diligence in that.
Yeah, but yeah, it's been good.
Cool. Well, talking about deal flow, right? And you get capital your way, I get capital my way. Well, what you and I heard through grapevines over the years, is a lot of people either think of raising capital as a way of going through it, asking a friend, a family for some money.
Yeah.
What have you heard? What have you been told? What kind of stories have you heard from people who are getting money or getting in?
All kinds of things. I've known people that have put notes on a credit card, which I think is insane. But if you get a low balance, I guess you can justify it, but that's a little scary. Friends and family is a big one. The JV thing has been kind of the preached model for a long time.
Yeah.
And so that's kind of what we're here to address today, is what's okay, what's not okay. And we've got our expert here to help us navigate what's.
And to be honest, I started out joint venture. That's what I did, right? Because that's what I thought about when I thought about investing.
Yeah. So
oddly enough, like it made sense. Like, Nathan, give me some money. I'll do a deal. I'll give you the money back. And then when talk started happening about being not real, I just altered my paperwork saying, Nathan, can you call the attorney? Can you call the agent? And you're saying, I don't know what I'm doing, but I gave you 100 grand. Sure, I'll do that kind of tasks.
Yeah.
Then I started hearing more and more about it's still not possibly legit. And that kind of got scary.
Yeah. Yeah, no, you really got to watch it. And not something you want to mess around with.
So today we're joined by Nathan Dotson. Thank you for joining us today, my man. And for those who are not familiar with who you are, what you do, can you share a little introduction of yourself?
Absolutely. And let's not confuse Nathan and Nathan. Call me Nate, please.
All right.
So everybody other than my mom, when I'm in trouble, sticks with Nate. So I'm one of the principal attorneys of the crowdfunding lawyers. I have another law firm that we kind of do beginning to end. But today we're really talking about kind of the security side of everything. So background is over 15 years of doing only securities transactions, major financing transactions, primarily in the real estate world. Has been a few $billion in transactions over the years. Also do startups and some mergers and acquisition transactions, but generally it really does focus a lot in the real estate realm in kind of all the different facets. And the debt buying is an amazing area and a great way to make money. Of course, there's 1,000 different ways to slice it up, but our background, my background, my team's background is doing the securities transactions, the compliance, and making sure that everything is done safely and in compliance with all the, at least US regulations.
Yeah. Right on.
So let's start off. What is SEC?
The SEC, it is the Securities Exchange Commission. They are the regulatory arm of the US government, and they are really creating and enforcing the rules in the securities realm for the companies and issuers in their jurisdiction. And to kind of bifurcate it, you do have the SEC on one side. You also have an organization called FINRA on another side, and they have regulatory oversight over broker dealers and kind of the professional traders, where the SEC is really paying attention to the securities exchanges, as well as have oversight and jurisdiction over kind of the issuers and the guys that are out there making the deals that are not broker dealer licensed professional investment people.
So who falls under the scope of SEC? Like, how does one pop up on their radar?
Quite a few different areas that they oversee. One being investment advisors, and they enforce the Investment Advisory Act of 1940. Investment companies, every company that's listed on a stock exchange have securities or the financial reporting requirements. They oversee all of that. In addition to, and now we're going to get to where it really applies, the guys that are issuing securities, or the guys that are issuing projects that don't even realize that it's securities, but surprise, it is, and it falls under the SEC's jurisdiction. And in the United States, it also falls under every state in the US has their own regulatory oversight commission as well. SEC being the big dog.
So Guy asked, hedge fund as well. They fall under the Security Exchange, and they had to file the paperwork to become a fund and to raise capital.
Yes and no. It kind of just depends on what type of security registration or exemption that you're falling under. It is possible to set up a hedge fund that you're only doing business in one state, you only have investors in one state. Then the state securities board or division actually has regulatory oversight. But if you're setting up a hedge fund that is operating in multiple states, all of a sudden it does become the SEC's jurisdiction, and kind of based on how it's structured, what their goals and guidelines are, maybe they have to fully register. Most of them try to figure out how to avoid registration through exempt offerings, but they are always dealing with investment advisory areas.
So what in note investing, what makes it fall under SEC? Is it because we're buying financial instruments, or because we're raising money, or is it a little bit of both?
Let me give you the kind of the standard. This is the test in the definition of what's a security. And then I'll blur the lines a little bit. But the most basic, it is pooling multiple investors' funds together for the purpose of making profit and making money. And it's being managed by another party, a third person. And all the investors, they're in common. They're sitting in the same pool together. So when it applies to and thinking about the note buying, are you pooling multiple people together that would have a similar interest in a promissory note? All of a sudden, you've taken what could be a non-security, now that you've broken up the note into multiple interest holders, it becomes a security. That's been the traditional rule, but there's actually been some changes going on in the marketplace. And it's just something to be very careful about. There are many hard money lenders, note buyers that will take down an entire note. And traditionally and still, that has not been treated as a security. However, if there's they call it a scheme of financing. If it's an overall plan of how you're funding your business model, there's not a problem until there is. And it is more and more the SEC has tried to take regulatory control over different areas. A little bit of a different situation, but I'll bring it up because of the similarity to the note buying. There was a company called Life Partners. Life Partners was purchasing life insurance policies, fractionalizing it, selling it off to a bunch of investors, and SEC sued them because they were not abiding by the securities rules. And Life Partners, they won. Their position was, well, we're just buying and selling these life insurance policies. We're not doing anything. We're not managing anything. There's no ongoing activity going on. But that, and Life Partners, they won. SEC didn't like that. And they kind of just started taking case after case against this same company in different jurisdictions until they finally found a court that gave the SEC a win. So after losing for basically a decade plus, the SEC eventually found a court, found a jurisdiction that said, well, you know what, you are raising capital for the purpose of these investors making a return on their money. We're going to minimize the extent that you're actually doing anything to service these life insurance policies. And we're just going to call it an investment. Now that company has gone bankrupt, and there's a whole host of securities issues and lawsuits that have been going on because of it. So it is always kind of a risk to pay attention to.
So if you're going to be in a joint venture, you and I are going to get into a deal together. Is that considered a pool of people if it's just you and me?
It depends on who's managing it. If you're the manager and I'm the investor and that's it, thinking back to that test, we're not pooling money together. You're an active manager, you are that third party, and you're using all of my money. So actually, it's not a security when it's just that type of a setup. But now you call Jim, ask him for his money. All of a sudden, now you are pulling people together. And there are exemptions, and if it's just really de minimis and doesn't quite fit the bill, maybe you get away with it until there's a problem. But at the end of the day, if you started having defaults, you're not performing to what you're telling the investor is going to happen, eventually somebody complains. And they don't complain to you, they complain to either an attorney or a securities regulator. And there will be some audit, and somebody is going to look into what's been happening. And the regulators have their own goals and their own strategies. But at the end of the day, they really are trying to protect the investors. So as the sponsors and the deal-making guys, you're really sitting on the other side of the table from any of these regulators.
So Nathan and I just described before, a lot of people tuning in today are looking to raise capital from their friends, family, whatnot.
Mhm.
What would be an appropriate way to do that? If they're gonna raise funds for the first time, they'll get 50 grand from somebody.
The appropriate thing to do is call an attorney. Talk through what the plan and goals are. Visit us at the crowdfundinglawyers.net. Happy to have no cost, free consultations to talk through ideas. But it's very important to pay attention to what are you trying to accomplish? How are you going to find your investors? What you're expecting the investors to do or be. Friends and family can generally be, they call it Reg D Rule 506B, where it can be a limited number of unaccredited investors, unlimited accredited investors, but you're not allowed to, they call it generally solicit. You can't put it online, you can't market it everywhere. But there are kind of some streamlines to that, but there's also a lot of requirements. You don't want to get caught. There's specific securities regulations behind those as well. Again, just talk to an attorney.
Okay.
So so what we're hearing a lot of people is the Howey test. Is being a guide to know if what they're doing is legal. What's your thoughts on that?
The Howey test is exactly the test that I described. You can use the legalese terms and everything else, but the Howey test is specifically the pooling together investors with commonality, managed by a third party, and doing the deal for profit.
Okay. But if I'm keeping it separate, like if I've got one investor for whatever, 2 notes, and then I've got a different investor on different notes, and I'm keeping everybody separated, are we okay there, or is that crossing over blurry?
It is not necessarily black and white, but it's not necessarily doing wrong either.
Okay.
Because you're not pooling investors' money. They have distinct interests.
Mhm.
You do that long enough, though, it becomes just selling a note by note to potentially, adding fees, adding management responsibilities, adding this and that, adding that. It becomes the scheme of financing for your business. And again, if there's ever an issue, a state regulator or the SEC will dive in and look at everything that you were doing. And if they decide that, oh, if we integrate all of these activities together, you've violated a securities rule, then you're still dealing with a headache. And I said integration. What does integration mean from a security standpoint? If somebody is doing multiple securities transactions, the state regulators or the SEC can look at everything that you were doing, combine it all together if it's meets certain characteristics, generally, minimal, happening simultaneously. They're not being breaks. You're selling the same asset repeatedly. Notes is kind of unique because it's like real estate. Every property is unique.
Yeah.
But you do it long enough, and if there starts being problems, you end up in the life partner situation of, even if you win, eventually they'll find a way to get you.
And what are the kind of penalties that you can get by violating?
Jail.
Really?
That's yes, absolutely. Securities fraud can end up in jail, and I've known people that have ended up exactly there.
Wow.
In a better case scenario, which is a horrible scenario, you owe all the investors their money back. You owe a designated interest rate, and you cannot discharge it through bankruptcy.
Wow.
So you also can end up with a major debt that follows you forever.
And most of these investors are doing a 50-50 equity split on the deals, where they're getting into a deal. Nathan gives me 100 grand, I go into a deal, and if that deal makes money, I take 50% of the profit. He gets 50% of profit. That deal's done, and I go to you, Nathan, and say, listen, I need another 50 for another deal. And that's what we're seeing them do. Or they're going back to Nathan and saying, hey, okay, another 50 grand, got another deal coming through. We're seeing a lot of that. And it sounds to me that if you do that repeatedly, that's when the problem could happen, where it looks like the basis of your business.
Exactly. And you really nailed it with the basis of your business. If what you're doing is buying and selling investments, whether or not they can be construed as securities or not, if there's a issue, a major problem, a complaining investor, you're still calling them investors. You're just trying to avoid treating them like investors. When that takes place, then the state or the SEC steps in, does their own review, and starts this, well, it's your business, let's integrate it all together. Now do you have a problem? The safe thing to do, and this is the smart thing to do, is only work with accredited investors. There is, even under the different types of securities regulations, there are less protections for accredited investors. What an accredited investor is, categorically, they're the people that have a net worth more than $1 million. If they're single, they're making at least $200,000 a year. If they're married, they're making at least $300,000 a year. And there's a whole bunch of additional categories. Being securities licensed now, certain securities licenses, they're treated as accredited investors, and really that just means they should be able to take care of themselves. Whether or not that's actually true, that's the regulations. And with that, there's generally not a lot of disclosure requirements for accredited investors. And so if you're in the note buying, selling business, best advice would be only work with accredited investors. And then even if the regulators step in and they combine everything together and say, is there a problem? The response gets to be, well, no, everybody's accredited. I don't have too many investors. I don't have certain disclosure requirements. There's not a problem there. So that's the easiest fix.
Okay.
So we had some questions in the chat here, and I'm trying to post them to the
Got a bunch
Here,
of what-if
so-
questions.
what if I, the investor, offer to lend somebody, I guess, I bring another financial investor and the manager does not make the initial call? I guess that the person who's collecting the money isn't making the call. Robin, if you can clarify that a little bit.
You know what? I'm going to talk, just kind of explain something that it'll apply to that situation and many others that you guys are in the middle of. To sell securities, to sell investments, you either need to be registered and licensed or exempt from registration and licensing. And everybody, most of the people listening, if not all, they don't have their Series 7, 65 or whatever it is. So they are relying on an exemption, and the most commonly used exemption from being licensed to sell securities is, we call it the issuer exemption. And what the issuer exemption is generally is you have an ongoing working relationship with the issuer of the securities. The primary purpose and duty is not to raise capital. There's other material activities that are ongoing and expected to be ongoing beyond just this small raising the capital time period. You're not getting compensated for bringing in the capital. If commissions are paid, even if it's getting paid to the president for bringing in an investor, that's a broker-dealer activity, and licensing and compliance is required with that. There are also a bunch of different bad boy situations that literally people are just barred from doing private investments, directly being control people, really being involved with any sort of Reg D offering, period. And then additionally, there is you can't actually have been licensed with a broker dealer for the past year. Just they're trying to stop people that either got fired or just said, hey, I'm going to jump ship and go work on this side because there's a lot less oversight.
Mhm.
That's the reason why that's one of the prongs of the rule.
All right.
So I think the next two questions, Nathan, is really almost the same thing. So you want to cover it?
Talking about silent partners in an LLC, or what if two or more investors form an LLC, then they do a joint venture within that LLC? Is that considered a security?
If they're doing a joint venture really doesn't mean much, if you ask me. I would call a joint venture a general partnership unless it is, an LLC or entity that they all have some sort of management and control relationships with. And to go back to that, I love that you brought up Howie. Talk about it all the time, but if I say Howie, people are like, who's Howie? Not Mando. So if they are both actively involved with the company, regardless of how they put in their capital, it doesn't meet that investment securities test. So that's not a material issue. Once that entity, that joint venture invests into another, you have to do a whole nother analysis. And was that company set up to invest into this other deal? And is this other deal selling a security? If so, how do they have to treat that joint venture entity? Is it accredited? Is it unaccredited? Do you have to look through and consider each one of the owners? Or can you look at the entity itself? And just to kind of touch on it, if an entity is set up specifically to invest into these other securities, a special purpose entity, you almost always have to reach through that entity and consider each one of the investors individually.
Wow.
If they're all accredited, the entity itself is accredited. If one is unaccredited, one of the owners of the joint venture is unaccredited, then that would account against the limited number of unaccredited investors that could be accepted.
But I presume that if you have a company, if I'm in partner with you and I'm raising money through the LLC, you're protected with your part of the LLC. Would that be correct? Instead of doing a joint venture raising money, we just form a company together. And in that company, we take equity, just normal equity, and you bring in the funds. Would that be appropriate?
Little confused.
Okay, so if me and Nathan go to form a company, he has 100,000 and I form LLC with him, is that, and we're buying loans through his money, my working, is
Mhm.
that legal? To avoid the individuals, now we're one entity.
Why is that any different than what he's already doing? Other than now you just threw an LLC in the middle of it.
So that would answer a lot of the questions out there, that if you have a silent partner inside the LLC that's doing nothing but giving you money, that's still seen, because the umbrella LLC is not protecting you at all. It's really still, he's bringing the money in and you're calling an LLC as an entity.
That is correct. That doesn't add some layer of protection there. Not at all.
Awesome. I know Ray has a question too, Nathan, if you want to jump on that.
He's got had a relationship with one investor, and I sourced the note with my investors. Hold on, I gotta read this too. If I have a relationship with one investor and I source the note and my investor buys 100% of the note in their LLC or self-directed IRA, then the self-directed IRA buys a partial
Oh,
of the
jeez.
note. This is Ray. I love his creativity. Giving me an interest in their note, and then they give me written permission.
So it's not like a brokering thing going on there. It's not like a couple things.
It also looks like some related party transactions that the IRA custodian may have some issues with as well.
So just to let everyone know, I learned this hard way. Once you do a deal individually with somebody outside the IRA, and you're more than 50-50 partnership with them, they are now a disqualified participant, and you can't do a deal inside your IRA with that person. Just like if they're a parent or a child, they're disqualified. So I learned that the hard way a couple of years ago. So
That's an expensive lesson.
yeah, luckily I didn't get in trouble. It was when I realized it doing one of my, one of the webinars, or it was actually at a conference, we went back and changed the numbers, percentages to avoid that issue. Hopefully we do. So we're talking about all this stuff. People want to know how to structure a joint venture agreement correctly. And my direction will be to talk to you guys and talk to attorneys to find out if what they have is correct, right? And see if what they have built is correct. And I know people out there may not want to spend the money to go do this, but I promise you the money spent now will be a whole lot less issues, problems, trouble than if we come into a problem later with the SEC. Jail time, fines, everything else, right? There's a whole lot of things you have to worry about. Cody has shared something in the Facebook Live of the SEC government stuff. So now we're in a situation where we're kind of getting worried about this, right? And we wanted to do this correctly. What is the next step of raising capital the right way, as we're discussing with you today? What I'm worried about what you're saying. I'm on the edge. I'm doing a lot of deals. I'm joint venturing with a handful of people here and there, buying notes. Oh man, this may not be right. I may get myself in trouble here. What do I do?
Definitely reach out to the most qualified attorney and law firm to make sure that you're doing everything properly. We of course love to talk to and work with everyone. You can find out our information at crowdfundinglawyers.net. But really, you can't just talk to any lawyer. Securities is a very specialized and technical area. Frankly, most attorneys not only don't practice it, aren't allowed to practice it by their errors and omissions, either E&O insurance, because of how much extra oversight, time, and risk it really takes. So as an example, we actually work with attorneys daily across the country, and they're focused on the financing and the transactions, but they refuse to touch the securities part because of the level of risk, because of the restrictions from their insurance to really be able to do much. So definitely talk to a qualified attorney that's specializing in investments and securities, and just know it's not Jim down the street with the shingle out front.
So I did
First
what I
attorney
did
is
do in
different
the
than
I did
litigation
the
attorney,
Facebook
different
Live
from
feed in the chat box. I shared a Google form. What we're gonna do is anyone who wants Nate's information and contact information bio, we're gonna send you a PDF of the whole thing. Just fill the form out and you'll immediately get the whole bio and everything else from Nate. So a lot of people ask the question, it's a general question, how much and how long, right? And this can scale from what type of SEC fund you're gonna run, how big, how many accredited investors, how many not, and things like that. What kind of generalization do you give an investor who wants to do this? How long and what kind of cost is typically involved?
And does it make a difference if they're brand new or if they've been around for a while? Like what's some advice for those groups?
So we kind of do it a little bit different with crowdfunding lawyers. You call just a regular law firm, you should be expecting around 35 grand for kind of the beginning to end of the getting a private investment set up. And that's kind of been the standard for many, many years. There's also websites that you can find really the dirt cheap, plug in your information and it spits out whatever your offering documents are. There's not really any attorneys involved. You're not getting an advice. You're getting a templated form and good luck with life. So we're really doing it very differently than a lot of what's in the market there. We base our costs based on the size of the deal. We know that, hey, there's more capital you're raising, there's more work that's required, there's more risk, there's more consultation and follow-up. So, and everybody hates getting ongoing attorney's fees. surprise, I got a phone message from you. That is, let's just call it 6 minutes, 0.1 of my billable hour rate. Let's send it right over to you. That's how most of the market works, and not a fan of it at all. So the way that we do it is we charge just a fixed fee based on the amount of capital. And it ranges from, if you're only doing like $1 million deal, it starts at like 10 grand. If it's a 5 million, it gets up to 15,000. And then it scales all the way up to, if you're doing $100 million funding projects. Generally, we don't care what kind of securities exemption you're going under. We want to make sure that you, based on your situation, your network, your marketing plans, your investor plans, that you fit the right box and we do the right process. So we don't care if it's crowdfunding, a friends and family, online solicitation. We don't care. We're there to kind of work with you through the process to just get the best deal together and available. The only exception is we do represent Reg A offerings, and Reg A is just kind of its own animal. It's like a mini IPO. You can raise up to $75 million from any investors, but there's a qualification process that actually everything gets filed with the SEC, and there's ongoing filing requirements. It takes longer. A lot of back and forth with the SEC, and your information is out there in the public, but a great way to really take it to that next level.
And you'll go on the website and you'll find something that looks like that. It's a big giant chart. It shows you all of the different possibilities and what's included in those, and what are the regulations and steps.
And most of the time, from my knowledge.
Whoa.
Yeah,
Just real
okay.
quick. Thank you, my name brother, for bringing that chart. I'm going to tell you right now, it has not been updated since there were some major
Okay.
securities regulation changes literally 2 weeks ago.
Right.
The whole game kind of changed just within the past month. So we still have to update that chart, but we will, and now we really will in the next few days.
So, from what I've been told, most of the time the cost goes up or down, depending on the money size, but also what type of fund, how many unaccredited investors you want to get in there, and how many accredited investors. Are there any other factors that increase, decrease the cost dramatically based on that one factor?
No, not for us, at least.
Okay. And how long does it take for this process from beginning to end typically take?
A good target is a month. Our average is probably 3 weeks. If everything is known, this is what we're doing, let's hit go, we can actually get them done in a couple of weeks. This is our specialty. This is what we do. So we have a pretty streamlined process.
Awesome.
And I can attest to that. We're cruising right along. We're doing great. Making some final decisions right now, but we're getting there.
In the newest change, has there been anything that investors like us, we should be worried about, or any concerns that change for us dramatically?
Some massive changes, not concerns, but benefits. I'll touch on a few of the big ones. That 506B Reg D offerings, it used to be you could only have 35 unaccredited investors, period. That's now changed. You can have 35 unaccredited investors in any 90-day period. It's a rolling 90-day period, but all of a sudden that 35 cap is gone.
Wow.
Another major change is integration, where I was saying, hey, you're doing a bunch of different offerings and they'll combine it all together. That has changed from they call it a safe harbor. As long as you were doing an offering and having a 6-month break, they would not integrate it. The SEC has now shortened that 6 months down to 30 days. Now you're moving forward with the deal. Hey, I'm going to do something else. If you close one, you're working on the other deal, but you're not offering it out for another 30 days, not going to be integrated. That integration is really what catches a lot of sponsors and issuers in dilemmas. So they've made it a lot easier to work with. And then one more really major change is in the crowdfunding world. Regulation CF, the real crowdfunding. You can have unaccredited investors, accredited investors. There's not any of the 35 limits. There's just limits on how much unaccredited investors can invest. However, it was capped at $1 million, $1 million and change, basically completely worthless. How are you going to be able to accomplish that? They've increased that maximum now to $5 million per year. So it just expanded greatly the ability to be able to raise capital from the unaccredited and accredited through general solicitation. It's just a matter of doing it the right way, having a great crowdfunding portal to work with. But they've really expanded the usability of the crowdfunding regulations.
Very cool.
It's amazing. The world is changing dramatically quickly, and all this opportunity is there. I know personally have seen many funds open in the last 6 to 8 months. Nathan being another one of them. There's a lot of funds opening up, and I'm sure there's multiple reasons. People are finding out more about it. People are being more aware. People are more concerned. And the fines, like you said before, jail and money. With most investors who get involved in this or get in trouble, quote unquote, is it typically the state or the federal part that typically comes at that investor?
Just kind of depends on the size of the problem. The SEC or the FBI tend to not get involved. I'm not going to say they never get involved, but they tend to not get involved unless you're talking about over $1 million. The states will get involved for less than $1 million, but they actually may still be involved if it's more than $1 million as well. So they have jurisdiction kind of going across the board. The feds just tend to not care as much as the small guys. Let the state handle them.
Awesome. Well, it's amazing because a lot of people are probably to call you up just to read over the joint ventures, right? And I'm sure you guys will be happy to do that. And they really want to know, hey, can I make, instead of me spending 10 grand to do this fund, I'm going to do a deal with Nathan. I'm going to raise some money. I want to make sure my joint venture is correct. Those kind of things are always questionable things. And there's a tons out there that are doing both ways, right? There's tons of funds out there. And these SEC funds are able to be looked at and reviewed by, the government, stuff like that at all times. So that's the interesting part, because there's more than just opening a fund, right? It's not just fill out paperwork and you're done. There's always follow-up.
Always follow up. There's always compliance. And so kind of part of what our services are is we do continue to follow up with everybody that organizes an investment platform with us. There could be state filings, SEC filings that really are time sensitive. So we do have somebody that continually follows up with all of our clients, making sure that, hey, what's going on? Is everything good? Do you have questions? New investors, do we need to take care of some more filings? So that's kind of an ongoing thing throughout the capital raise time period. And then also we recognize that it's not just, here's some documents, have fun. We do offer an ongoing reasonable consultation. We're here to answer your questions. Marketing, investors have questions. There's how can you accept this type of person? What about suitability? A lot of stuff comes up. And you can call that attorney that bills for every 6 minutes, but we just like to include it as part of the package. So hey, you're off and running for 6 months, we're expecting that you're going to have questions, and we're there to help and support you.
Yeah, fantastic.
I think it's interesting. It's a totally different world.
That it is. 2021. We thought 2020 was weird.
Have you seen influx of people coming to you in the last year or so that are looking to open funds? I've seen a lot. Have you seen influx?
Definitely. I mean, it was the pandemic. 2020 was just a weird world. We all experienced that. April, the world shuts down. There's all of a sudden every real estate transaction that we had in process, it was in the books, stopped, halted in its tracks. And some of them fell out, some of them just got delayed. Really, it seemed like the sellers were working with most of the people and understood, hey, we couldn't, capital markets were frozen, loans couldn't be made. It just, everybody kind of understood.
Yeah.
Around August, September, there was like this catch up. Like, okay, well, we actually think that this is all going to be okay. And so it was not like getting back to normal. It was a catch up from all of these months that there were just delays in closings. That's kind of been continuing, and now we've got these new rules coming into play that makes raising capital easier and from more areas. So life is golden, and we just keep moving and shaking.
Very good.
Well, Nate, I appreciate your time.
Yeah.
I appreciate your amazing knowledge to all the people watching and those people who watch later. That you've been tremendous help to us, but also being willing to answer questions in a more personal kind of relationship kind of thing. So, I appreciate your time, and I know Nathan been working with you closely, so you've been highly recommended.
Yeah.
Well, Nathan, it's always a pleasure talking to you. I'm loving actually the first time I've really seen you in person. David, great to meet you as well, and everybody out there in Facebook land, love to meet you too. And you know how to find the information.
Yeah.
Awesome. Thanks so much, Nate.
Thank you so much, everyone, for watching, and we'll catch you guys next week. Thanks a lot, guys.
Thank you.